Scano Segovigo, Director of the Land Resources Department for the Six Nations Elected Council. To my right here is, you probably already know him, Phil Montour. He's our land rights consultant and has been involved in a litigation, or not litigation, but the research actually, going back to 1974 onwards, and he's still involved. Not so much research anymore, more with our team, which includes me and Taylor Hill, the assistant director. We are the body, the group that is advising council with respect to the litigation, and we have constant contact with the litigation lawyers, our lawyers, so we're managing that on behalf of council. So, you know, that's our function. That's what we're here today. And our lawyers will be coming shortly, I understand, and they're going to be Robert James of the law firm of JFK Law and Max Shapiro of the law firm of Blake, Castles and Graydon. And Blake's Castles and Graydon has been involved in the lawsuit. They started a lawsuit on our behalf in 1995. So they know a great amount of knowledge on the case. Plus, they are both the law firm, both Robert and Max Shapiro and Iris Antonius from the Blakes are expert Aboriginal law lawyers. They know the Aboriginal law, and I really appreciate that we have them on our side because, we actually did start the trial a month ago, at the end of August, in the sense that Canada has 3 of its expert witnesses are elderly and sick, and so they made a motion to have them give their evidence before the actual trial starts. So we don't have a trial judge appointed yet, but so it has been, that did go on for the first witness for 2 weeks, and a second witness for another 2 weeks in September. And it was quite amazing to see how they operated and all admissions they got out of the Crown witnesses, particularly with respect to Professor Colin Reid, who was Canada's witness. But he made a lot of admissions in our favor, and as a result, of our cross-examination by our team, particularly by Robert James. And it was really a sight to see. So, there's more to come on that. We haven't got a trial judge appointed yet for the trial, but we're hoping that'll be done end of this year, first part of New Year, so we can look at starting the trial in 2025 sometimes. But, so, as I said, the court case was started in 1995. It's a huge case as far as evidence that needs to be presented. It's a documentary case predominantly. We have to rely on a lot of historical experts, and we do have a lot of historical experts who are about to give evidence, who have filed reports, and they will be what we'll be relying on when we have to tell our side of the story of how we were deprived, defrauded, and cheated of all our lands and all our monies in essentially from 1791 to about 1845, when all of it was lost. And it was all done, in our opinion, unlawfully. And it stands to reason. We had, by the Haldimand Proclamation, 1784, we were granted approximately 1 million acres almost of land that cuts right through the southern Ontario. By 1845, it was almost all gone. Except for what land we have left now, the 46,000 plus acres, and the money that was obtained from any of those so-called land sales. We had substantial amounts at one time. My own research shows that by 1870, it was pretty much all gone. And that's for 1 million acres, and it's hard to believe, and I just can't believe the injustice that occurred and in losing that. So that's what. So the court case is about not about land back, And the lawyers are going to explain that more fully when they get here, because if we had to do a land back suing for the land, return of the land, it's in some cases it's 200 years old now when it's been out of our possession, and it's owned by third parties. Their provincial land system where they own it fee simple and so forth. So we would have to sue millions and millions of owners with respect to getting the land back. But and there's already been a court case decided in 2000 called Chippewa's Sarnia case, which says that in regards to getting land that was illegally taken for Indian First Nations to get land that was illegally taken from them by an illegal surrender, that you have to start that case as soon as the event happened, and it can't be 100 years or so later, which is what happens with the Chippewas Sarnia case. They lost their lands through an illegal surrender, and they sued all the third-party owners of the land, which quite a few in that case, where their lands are all taken over by industrial companies, manufacturing companies that are polluting their land and their air. The court says no, because of the statute of limitations, the doctrine of acquiescence latches. You waited too long. You can't get a remedy against the third-party owners of the land. But it said you can get relief from the Crown, who is the body that was responsible for having your land surrendered, which it didn't do in this case. You can start an application, a court action against them for breach of fiduciary duty. So that's what our court case is all about. We're suing the Crown for the illegal manner in which they took our lands. A lot of those treaties were not done according to what the laws at the time. Or in fact, there's no treaties, there's no surrenders whatsoever. And I always point out that the whole of Oneida Township, there's no surrender for that. And there's a lot more instances too. I know Phil has researched a lot of those and knows a lot more than I do about how those lands were taken in a legal manner in which they were taken. So that is it always bothered me and it bothers a lot of people to see how that land was lost. We looked at we can look at a lot of instances and say money wasn't paid, land was given away free, Six Nations didn't recover anything from that. We take instance of the city of Brantford. A lot of their lands, although there was a so-called surrender in 1830 of the Brantford town plot, a lot of that land was never paid for. And so how do you, that's just part of the larger court case, and there are thousands of transactions like that occurred, and which is part of the lawsuit. So the lawsuit is for breach of fiduciary duty against the Crown, both Canada and Ontario, for the illegal manner in which they took our lands, and for any money that was obtained in the disposition of those lands that they illegally misappropriated for themselves. And so it is really, and we're talking about, illegal losses that occurred almost 200 years ago, and it is a substantial claim with interest and so forth. So it is a huge monetary claim. We could never ever put a value figure on it because it is just simply too large. And I know the lawyers are going to here to explain that some developments that have occurred recently in other situations, and the Robinson Huron is one that's been in the news where, we all know people from there, the Robinson Huron Treaty area, and they are getting individual payments for their court case that they started in the early 2000s. But their case is for a breach of treaty payments, which is a lot different from what our case is all about. In that situation, in 1850, when they surrendered all of their lands, they were guaranteed that each individual would get, of their particular First Nations, would be getting treaty payments per year at a set amount, and it would increase based on the fact that as the government took in more money from the use of their former lands and their resources, that their treaty payments would increase. But I think they only increased it a few times after 1850. Maybe 1870 was the last time those individual treaty payments were increased, and it stayed that way ever since. So there was a huge claim for all of that money that should have been paid because of the increase in the revenues that the government was getting, and that's Ontario, and there was none. So their case ended up. It's in the billions of dollars. Of course, we've all heard. Now there are two parties to that court case. All the First Nations are Ojibwe nations along the north shore of Lake Huron and Lake Superior, and the Lake Superior Ojibways took their case to court. They didn't want to settle it, but the Robinson-Huron treaty area, the nations there agreed to settle, and they agreed to settle on a payment of $10 billion. So that's what is being divided up among all of those individuals up there now. And not all of it. Some is being set aside for future generations, but I think on the average the split is 70-30. That is 70% of the total amount will be paid to individuals per capita payments, and 30% would be held back by the individual nations for their future generations. So it is a lot different from what our case is all about. As I tried to explain, ours is for breach of fiduciary duty, illegal manner it was taken. We don't know, we can't put a figure on it at this point. We don't know what it is, other than say it's worth a lot of money. So that when we talk about, what are we expecting to achieve, and I already indicated we're not asking for the land back because of court decisions, but for breach of fiduciary duty and for trust accounting. They held this money, the Crowns held this money, the colonial Crowns, Upper Canada held this money in trust for us, supposedly, on the sale of those lands, and we were supposed to benefit from that, and they spent all their money into their own uses to build the colony of Upper Canada. And Six Nations, while there were some payments made, it certainly wasn't a case where, for that amount of land, for an amount of money that we should have obtained, should still be enjoying that today. But as I said, by the 1870s, everything was pretty much all gone as far as the trust money goes. And of course, most all the land was gone as well. So illegally taken, no surrenders and so forth. So that's just a little bit of the background of what we're here today, is to update the community on what the court case is all about, and also what we've done so far as prosecuting it to reach a final conclusion. So that we have a lot more work to do there yet. We're hoping that sometime that the Crowns are going to, as I've indicated in the press before, that the Crowns are going to come to their senses and say, we can't win this case. The faults are too damaging, too egregious, too obvious, and that the Crown did in taking our lands and money. That let's sit down and try to resolve this. We're hopeful that's going to come, but I keep telling people that the claim is so huge that they're scared to sit down and talk about it, and that's the reason why we have to keep pushing them in the court case, have to keep pushing it on for trial. Because some point in time we're hopeful that they're going to realize that they got to sit down and talk about resolving this, and so that we can all benefit, however that turns out to be. So that's a little short summary. I hope I didn't take too much thunder away from what the lawyers are going to say, but I don't know, Phil, whether there's anything you wanted to add on that?
Well, you kind of said I've got to say something, I guess. Well, it's been a long battle to get us there in the collection of the facts. And this is what it's based on, is collecting that evidence that was kept from us. Because when we started in 1974, we basically had nothing. And it's been through the work of the researchers. And the last ones sitting around here are at that table number 2 and a couple on the wall who have worked on this. And their endurance through this and their wealth of knowledge they've gained has actually got us to where we are in a court case, where we're basically, we can outprove Canada and Ontario. Now, we're caught up in the court system, and you know, we've tried in the past to negotiate with Canada and Ontario, but there's no honor in the Crown. You know, they just insult you. So unless we get a hammer and decision by the courts that the Crown has to act in good faith and negotiate this, and I think that's where the point is, then we got to have input from the community. How are we going to move forward as a community and for future generations? Because that's what the Haldeman Treaty was set up as, from them and their posterity to enjoy forever. So although it's not the return of land, it does not mean we won't control the land to some extent and sharing it with our neighbors. Obviously, we're going to get a lot of land back. That's not an issue, but it'll be on the open market and where we want it, because that'll be part of it, because our reserve has stayed the same size since about the 1843s. You know, our population has grown immensely. And there's a lot of frustration, there's development going on around us, you know, and everybody's finger pointing back and forth. Canada's supposed to be consulting with us, Ontario's supposed to be consulting with us. They turn it over to municipalities supposed to be consulting with us. And then they turn over to developers are supposed to be consulting with us. Well, this is going to put an end to all that. You're going to be back as the landlords of this and the management of these lands. And there'll be revenue sharing. I expect how it'll go. There'll be revenue sharing from any transactions, any involvement on dealing with these lands, that it'll be coming, we'll have a revenue stream coming down to Six Nations. So we can take care of our proper health care. So we can take care of our proper housing issues. You know, all the things that we've been denied of through these years. But what's a bit contrary to this, it won't be a one-off. It'll be an ongoing situation based on the terms of the Haldeman Treaty. So I think that's what's really got to be understood. Canada's used to coming into town, cutting a check, and you guys, your rights are done. That's not the case here. We've got a lot of evidence on the research that was done. We got expertise. You know, and of course we got to bring in other experts on the economies and some of the legislative authorities that were put in place actually to take our rights away from us, legally or illegally. And those are the things that we're challenging in courts. This is not easy. It's big, very big. But as Lonnie pointed out, I'm very pleased with right now how our lawyers have orchestrated us and are giving our evidence the justice that it's going to need. That's a history going back since 1974 up until, well, we're still doing research constantly, depending what questions they come up with. But you've got a strong research team that's still here. Our own people are going to have this knowledge and continue with that. I think I'm just waiting for the lawyers, because now we've placed all this information in their hands to beat Canada, to beat Ontario. And right now they're just pointing fingers at each other. Who's going to pay? I don't think it's a matter of win or lose. We may not win at all, but we're certainly going to win a lot. And I think the big challenge that they're faced with, who's going to pay and how are they going to pay? So that's basically my summary on that, Lonnie.
Okay, thank you, Phil. You know, one thing that occurred when we did this, I said the trial started, that occurred in a trial. The procedure was that Canada was present their expert witness, and you know, they can't cross-examine their own witnesses. We can cross-examine because we're adverse in interest, obviously. But Ontario tried to say that they're entitled to cross-examine Canada's witness too. And so you could tell that they had kind of orchestrated this whole thing, that if we objected to any of the questions that the Crown might ask their witnesses, and we got a ruling in our favor saying that it was an improper question, and we did have a judge, a Superior Court judge who was assigned to the case, and his job was to make evidentiary rulings on what questions can be asked, and if they can't, what questions can't be asked. So we objected to some of the questions that the Crown was trying to ask their witnesses, and the judge ruled in our favor in those instances and said, no, that was improper questions that you were asked. But so Ontario says, well, if they couldn't ask it, we're going to ask it. We can ask it on a cross-examination. And we said, no, you can't do that because you actually are the same parties, whether you admit it or not. Canada and Ontario are the same parties that we're suing, and when you look at it, they're not adverse in interest. And so that was our main point about stopping Ontario from any screw-ups that Canada might make in asking questions of their witnesses. And the judge ruled in our favor. He made a decision that, yes, Canada and Ontario are not adverse in interest. They are the one and the same defendants, the Crowns, and that was an important ruling. I know it's just a ruling in our particular situation where we had to have an early presentation of evidence because Canada's Crown witnesses were getting towards the end of the line, and but still, that probably will be raised again when we start the trial, and when they're going to try those taxes again, and when we have a trial judge assigned. So we've got it just goes to show, that we're right in what we say and everything, that this whole thing was a huge miscarriage in what they did in the 1800s, and that there's no difference between whether it's Canada or Ontario. They're equally liable in our eyes. And that's the other thing too, that about when the trial does start, because it's such a huge case in the sense that you have to have a lot of expert witnesses to present your case, both our case, Canada's case, Ontario's case. That and that's the other thing too, that I haven't addressed that yet, but so it's going to take a long time to do this trial, and we just saw that with these two witnesses that we had present evidence so far. It took 4 weeks just to get those two witnesses done. So anticipation with all expert witnesses, they're going to have to be presenting evidence. It's probably going to be a case where it's going to take almost a year just to do the first part of the trial, which is is the Crown liable in this lawsuit, and so the case has been what they call bifurcated, meaning it's divided into two. First, that issue is who is the Crown liable. Once it is determined that they are liable, which we certainly think that will happen, then the second part of the trial begins. Well, what are the damages that they have to pay? And that'll be another, I don't know how many days that's going to take. It's probably going to take, I don't think it'll be a year, but it'll take months anyway to get that issue resolved. We have to go that route. If we have to do the trial, if we have to present evidence, and Canada and Ontario have to present evidence in their defense, because we are the Six Nations is prosecuting the case, means we're the plaintiffs, so we have to present the evidence first. So we're going to be going first once the trial does start, and we'll have all our experts give evidence, and Canada and Ontario get to cross-examine them as well. Now, Phil did mention that there is another party that's involved in this court case, and it's New Credit. Mississaugas of the Credit First Nation. They made an application back in latter part of 2022 to intervene in a court case. They said that our claims were impinging on their claims that this is their traditional territory. And so they made an intervention motion to be part of the trial, part of the court case, and as an intervener. And we did have a huge days in court in May of 2023, and not only did we have to deal with that matter about New Credit's intervention, also the HDI, the Haudenosaunee Development Institute, also made an intervention motion, more or less saying that they were the proper parties and they should be prosecuting the case, not the Six Nations Elected Council. And obviously that claim really didn't have any merit. They didn't win on that. But the court did allow the Mississaugas New Credit to intervene on a limited basis. They have guardrails. They can't, they're not really able to contest what our case is all about. They're only there to preserve their rights to their claim that this is a part of their bigger territory that they claim, of course, which we're going to contest because we don't agree with what they say. That is, as far as we're concerned, they quit claim, they surrendered all our interests, and a number of quit claims that occurred from 1784 right till about 1820. So, it just stands to reason, that we let them live where they are now in 1847 because they didn't have any other place to go. They quit claimed all of their lands. So, but that's going to be part of the trial if it ever comes to that as well. That we're confident that we can prove that they don't have what they certainly admitted. They don't have an interest in the Haldimand Proclamation lands. They said they surrendered all that in their surrender of 1784, the Between the Lakes Treaty. So it's just that they're making this bigger claim to a larger area. It's even though they're making it, we just don't quite agree with that. We say no, they surrendered all their interests by quit claim of the whole area, not just the Haldimand Proclamation lands. So that's going to be that could be part of the trial too that will occur. So it's and they got expert witnesses too, and we got expert witnesses to counter that. So it is a long and complicated court case if we have to run a trial on the matter. So hopefully we won't have to, but who can say what's going to happen? But we're prepared to do that if we have to. I think elected council is prepared to do that. Take this to the end because there's justice at the end of the road. 3 minutes? I don't know, Taylor, did you want to say something?
I guess I'll just say, you might have noticed there's a couple sheets on your tables. So there's 2 FAQs. One's on our litigation, one's on the Robertson Huron. There's a litigation chronology, so it starts in 1994 to 2004, and then there's a litigation timeline, which is all the recent dates, and then there is also a comment sheet. So if you'd like to leave any comments or any questions that you don't want to ask out loud, you can leave those on the tables, and we'll collect them afterwards. And then there's our branded pens that you can have. I guess while we wait, if anyone has any questions right now for what Lonnie or Phil have covered before the lawyers get into more detail, please raise your hand. Daryl, can you hand over the mic, please?
Hello, yeah. So Lonnie was just talking about the hereditary chiefs attempting to intervene in the case and the judge ruled against that. I also noticed on the FAQ that the number 10 there asks, are the hereditary chiefs involved? And it reads, Chief and Counsel are always open to having respectful discussions with the hereditary chiefs. However, so far, they have not pursued this option. I was just wondering what a respectful discussion would be in this context, if there's any respectful discussion you feel that there needs to be had about this case.
That is an important question. The government views the elected council as a legal representative of the Six Nations, but they also recognize that the Confederacy Chiefs Council also represents a significant portion of the population, and they're recognized as the traditional government. And we all know they were at one time, and they still are, I suppose, the traditional government of Six Nations. And so if we ever have to talk about resolving this matter by settlement negotiations, they certainly would want them to be involved in some capacity. So we hold that door open to them to say, look, if you ever want to come aboard, and we're going to have to negotiate with what we want from the Crowns, that door is always open for them to participate, because we do recognize they do represent a significant part of the Six Nations population.
I guess in addition to this, in '94, when we were contemplating filing this litigation, we actually met with numerous chiefs. It wasn't at the Confederacy Longhouse. We met with numerous chiefs, explained the scope of the litigation, that is to hold Canada accountable for what happened to all of our lands and all of our money, and they basically understood that. And we held two other meetings with them once we filed the litigation in '95, and asking them, for their involvement on it. And they basically said they wished us well, but they chose not to participate in the litigation with us. So we did ask them back then, but I think as a community, we're going to get strong. We've got to come together and work this out. The political differences for the betterment of the entire community. I've been struggling with this all of 50 years. I've been working on this court case, and it hasn't changed. And it was on the mix before then. This is our downfall, people. We got an opportunity to really stand tall on this, but leadership, it's up to you to get this thing straightened out, hopefully, because it's needed. If we're going to go forward as a strong community, to me, it's needed.
Thank you, Phil. Robert James and Max Shapiro have arrived. As I said, Robert, we have essentially two law firms who are prosecuting the case on our behalf. Robert James of JFK Law, and Max is part of the team at Blake's Castles. They're here to answer any legal questions you might have, or even to explain just really what they see the court case is all about. So, Robert and Max, we've gone through a lot now, and just tell them with the background of it. So, if you have, I know you're going to fill in more details. So, we had got to the stage of whether there are any questions. We had one question so far, but if you want to just introduce everything the way you view it, what's okay with us.
Well, maybe what we'll do is we'll start off with, we're sorry for being late. The QEW did not cooperate in getting us here on time, so we got to tour the countryside. But first, let me just introduce myself. I think I know I've met some of you before, but my name's Robert James, and I'm one of the lawyers. And I've been, actually, I'm probably the most junior of the lawyers, since I've only been working on it for the last two and a half years now. And I'll just let Max introduce himself.
Thanks, Robert. It's great to be here, and thank you for having us. I'm Max Shapiro, as Lonnie said. I'm one of the lawyers. I've been on this case for about 8 years now with the team, and it's great to see everybody. Happy to answer any questions.
So since I'm coming in the middle, I'm not going to try to just give a spiel to you. I'm sure you've heard a lot from Lonnie and Phil already. I will just make a few brief comments, though. So I work exclusively in Aboriginal law, and I've worked here, and I've worked in British Columbia and done cases in other provinces. And I started out in this work back in 1995 was the first time I did an Aboriginal law case, and actually around the same time that this case was started. And, you know, so I've really had a chance to work through all kinds of cases involving reserves, cases involving Aboriginal title, cases involving consultations, such like that. And it is absolutely incredible how in the background of almost all of those cases is the story of the Six Nations and how the Six Nations came to be here, and then also the story of, over the years, how the Six Nations lands were eroded away. I mean, some of the earliest cases in Canada are about white people fighting over who's entitled to your land. You know, back in the 1850s. And there's a long history of that. And of course, there's also, and I suspect this is what Phil was talking about when we came in, there's also a long history of the government getting you to fight amongst yourselves. There's been plenty of cases about this. But, you know, what you're doing in this case is finally, after all these years, getting the government to account to you for what happened to all that land on the map that was promised to you in 1784, and somehow most of it has ended up in the hands of people who look like me. And there's never really been a good story given by the government about how that came to happen. And then not only how that came to happen, about how all of the money that was derived from that, which is a huge amount of money, somehow vanished. You know, whether it's into the pocket of white people associated with the government or whether it's into the Grand River Navigation Company, you know, there's never been a true moment of accountability for either the provincial or federal government for any of this. The British Crown managed to back out of its story many years ago and left it to these two governments to sort it out. And this is now the moment where the Crowns are going to have to account. So, you know, it's an important case, and I'm here, and we're here to answer questions about it, and I can already see there's a question right back there.
Sago. My name's Lisa Van Every, Mohawk from this community. My question, I have a couple questions. One is concerning the judge. I know in the criminal side of the law, there are a shortage of judges as well, and also JPs. So they said that they were waiting to get a judge. How concerned are you as lawyers that we get a judge for this case that's educated in not only Aboriginal law, but also Indigenous law and Six Nations history? And because judges come, well, they're former lawyers, but they come from all levels of education. And also the second question is, because you mentioned Aboriginal law, but Aboriginal law is different than Indigenous law. And how prepared are you to incorporate Indigenous law into this case?
Let me answer the first question first and then the second question. So the way that it works right now is that, so we are going to get a judge who belongs to a group of the judges who will do long and complicated trials. The reality is there is no judge anywhere in Canada who has been educated in Six Nations history or in Haudenosaunee law. Even the Indigenous judges, say on the federal court, are Cree or Anishinaabe, so, and they'd be quite frank about the fact they have been educated in these things. And in many ways that's good, because of the fact that what I find, at least, is that a lot of people think they know about your history and don't really know about your history. So in fact, what a lot of the case is about, and we'll have historians and we hope community members, will be actually about teaching the judge that history. Unlike, say, in the United States, where the judges are allowed to do their own research on history, in fact, it's a big part of the case will be historians speaking to the history, both about your history, but also about the history about how the government dealt with things. It will be, and this comes partly to your second point, we're talking to potential witnesses in the community to speak about your laws and your customs and about your language and your history from your perspective. And the idea will be is that actually we teach the judge what they need to know about your law. We teach them about the history, and that's what they're supposed to use rather than coming to the case with their own preconceptions. Our main concern, I got to say, is making sure that we get a judge who is experienced enough in running complicated cases and challenging cases to be able to control the way this case works. One of the major concerns we have is that the Crown has largely taken an approach which amounts to trying to delay things and create complexity, that's been their main strategy. And there's some judges out there who are not as good about controlling that sort of behavior as other judges. In this case, the senior judge in Toronto is actually going to be involved in hearing what's called the pretrial, so we'll be hearing from us about pretrial matters in December. He has taken a direct interest in picking out an appropriate judge to make sure that this case gets managed properly. So we're optimistic that we're going to get a good judge, but until we're told who the judge is, we don't know. To answer your second question, is Indigenous law is an important component of this case because of the fact that part of what we'll be dealing with is one of the things that the Crown is arguing is that you gave up your lands in many cases, that you, in accordance with your customs and traditions, gave up your lands, the proper surrender processes would be followed. And a good bit of the work that we're doing is actually showing how, for example, that a document signed by 7 chiefs, who aren't really identified very clearly, what their communication is with their clans, whether or not there was a proper council meeting and all these kinds of things, isn't something that was in accord with your law, and that it also wasn't in accord with Western law. So the components of your law are an important part of this case. And we're bringing that out in different ways. I mean, some of it is through the historians and the ethnographers, but as I said, and I don't want to, because obviously people are thinking about their place in the community and they want to be comfortable with things, so we are talking to people who in the community who know the language, who know the history, and who are considering testifying. And that is a large part of the work over the next year, is to build up that evidence as well as the historical evidence. Now, you saw that there was these question and answer sheets prepared. I don't know if people had a chance to read them. So have you guys had a chance to sort of just... Okay. So one thing that we've been alerted to is there's a lot of questions about the annuities case up in the Robinson-Huron area, where, you know, obviously there's been a lot of news recently because there was a large settlement up there. And, you know, I know that there's a lot of news about the fact that there have been a lot of distributions up in some of those communities in Robinson-Huron. And so the chief and counsel and Lonnie have asked us to talk to you a bit about that to sort of explain how that's different than this case. So that case is about, there's really two cases, one about the Robinson-Huron Treaty, which is the treaty that's on the north side of Lake Huron, and then the other one is about the Robinson-Superior Treaty, which is the treaty on the north side of Lake Superior. And these were treaties signed in 1850. They were surrender treaties. So these were treaties where they gave up their lands. In exchange, they got reserves, and they got some hunting rights, and they got an annual annuity. And the annuity was paid to the whole community. And in the annuity, there was a section that said that the annuity would be increased if it wouldn't cause the government to lose money. And but then it also said something about no more than $4 per person. I think it said actually £1 at the time. So the government increased the annuity in 1875 and then never increased the annuity again. So starting back in about 1999 for Robinson-Superior and 2015 for Robinson-Huron, they brought a court case saying that the government was supposed to increase the annuity. And what happened was that they had a trial about that, and the trial judge says they're right, that the annuity was supposed to reflect the fact that the government basically couldn't afford to pay a proper annuity back in 1850 because the government was broke. And so that this was kind of a deal that said, well, over time, as we start to make money from your land, we will give you a bigger annuity. And the judge said that annuity was supposed to have been increased. It wasn't increased. It went to the Court of Appeal. The Court of Appeal agreed. After the Court of Appeal decision, the people at Robinson-Huron actually settled the amount of their claim. So they settled for $10 billion, and the government has paid that money to them. The Robinson-Superior Treaty people have not settled. They took their case to the Supreme Court of Canada. The Supreme Court of Canada agreed that the annuity was supposed to be increased, but there had to be a process that was being followed, and that's still being worked out. So the Robinson-Superior people still have not settled their case. So the money that's been paid, the $10 billion, was a part of a settlement at Robinson-Huron. And each of the bands there have made their own decision about, you know, they put some money in trusts, they put some money out as distributions to the community. There's a fight going on with their lawyers over a contingency fee. So, you know, that's a very different kind of case, and it's very specifically about the annuities in the Robinson-Huron and Robinson-Superior case. Is that clear as mud? I think the major difference here, of course, is that the Haldeman Proclamation, first of all, isn't a surrender treaty. And secondly, of course, it also doesn't have an annuity in it. It just speaks to the Haldeman Tract. Oh, yes.
All right. I've got a couple of questions from online. The first one, is the 1841 surrender valid? That's the first question.
So we're saying no. The government, of course, is saying yes.
Excellent. And the second question, are non-SNGR band members potential beneficiaries?
The claim is brought on behalf of the band, and so the damages would be paid to the band, and the band it answers to the band members. So this claim is not being brought on behalf of non-band members. I do want to say a little bit more about can I just say a little bit more about the 1841 treaty, which is that surrender. We're saying that the surrender was invalid. we're also saying that even if it was valid, that the government forced it on you, and so that there has to be damages for that. And we're also saying that in the way that they sold the land off afterwards, they essentially sold it under value and still put your money into a sinking canal company.
Scano. I have a two-part question. I missed and I didn't get to see any handouts, so I don't know if it's in there. But what is your ideal outcome from this? And what is your expected outcome? And if the community or the Confederacy clans don't agree to it, what's going to happen? What happens in that situation? Is it just more fighting?
So, look, so first of all, of course, I'm describing what I think right now, and in the end, you got to remember something, like this is ultimately your case and your negotiation, so if it comes to that. But speaking as a lawyer who's worked in this area from a long time, my ideal outcome in this case would be that the Crown comes and engages in honorable negotiations with you, which, unless this court case gets closer to, the government tends not to come to the table until they have to, right? So we want the government to come to the table, and I do want to understand and underline that situation. You've got to keep pushing the government at court if you want them to properly negotiate, and that they negotiate with you, and that you reach a settlement. And that settlement could have a lot of different pieces in it, right? Because part of it's going to be money. There has to be a large amount of money paid to you. The reality is, this was a hugely valuable piece of land, and your leaders as early as 1790s were making it clear that you wanted this to be a source of support for your community indefinitely. And there's no way that that can happen without a lot of money being paid to you. How much? I don't know. We'd have to figure that out. The other reality is it's more money than Canada can pay, right? And so there's going to have to be other kinds of things that they should be doing for you. Like some of it could be paying money over time. Some of it could be committing to kinds of works being done in your community. Some of it could also be in the way that they recognize that you never really gave up the land. Now, that's not to say no one is going to be making Kitchener move, okay? I know some people would like Kitchener to move, but it's not going to happen, right? But the thing is that, for example, British Columbia recently settled a large dispute with the Haida by recognizing Haida title to their lands, and the Haida recognized the rights of people to stay, right? And so there was a respectful arrangement made where nobody was forced to give up their lands. And the government also recognized a process for getting land back over time, right? And so there could be all kinds of ways that this case could be resolved through negotiation. The reality is that as of today, despite the Chief and Council pushing on it, is the government has not come to the table to negotiate, right? We don't have a dance partner right now. And so that brings us to option number 2, which is that we're going to go to court. And if anybody ever sits in front of you and says that there's a 100% chance of winning a court case, you should fire them on the spot. But the reality is that there's a lot brought in your claim, and there's some extremely compelling parts of your claim, right? And my expectation is, I hope, my expectation is that a judge is going to say, because this trial is broken into 2 pieces. First part is, did the government do something wrong? If so, what? The second part will be how much money or other remedies. And my hope is that if a judge actually says to the government, you have done these things wrong, that then the government will definitely negotiate then. And that's exactly what happened in the Robinson-Huron case, right? The court said the government did wrong, and then the government did negotiate an honorable solution. So, I've got to say, my hope fundamentally is there'll be a negotiation, because one thing I always worry about with court, quite apart from the risks of court, is that, from my perspective, is your real goal should be to have more control over your future, your life, the things that you're doing. And, and that's what you're trying to get back from the government in many of the things that you're trying to do. The reality is that it's not a big improvement if you take things away from the government, one group of largely white people, and give it to a judge, right? Who's another, usually, not always, but usually another white person sitting in a black robe, right? The real hope here is that you will get to a place where there can be a negotiated resolution to this case, because a negotiation is something that you are an equal partner in with the governments, and it's not just somebody else making a decision. So my hope is there'll be a negotiation, but you can't make the government negotiate if they don't want to. And the only thing that I think is that's going to get them to the table is a trial.
Hi, I have some questions. One is, since the elected band council is an arm of the federal government and the Haldeman track is based on treaties between the Crown and the traditional council, how is it that the elected band council sees themselves as the rightful parties to be involved in this court case? Secondly, does the Six Nations elected band council have a treaty with the Crown? And does the band council is the band council successors to the treaties?
Right. So I think the important thing to know about the case is that the band council is actually not the plaintiff in this case. The plaintiff in this case, if you look at it, is actually the Six Nations of the Grand River. So it is actually it's all of you are the plaintiffs in this case. The band council, because of the court cases that were fought back in the 50s, 60s, and into the 70s, is the government of the band today. There's obviously a long history there that you know better than I do. But in the end, it is not the band council that is in court. It's not the band council that says they have the rights. The claim is that you as a group, you as a nation, you as a band, you have the rights. The band council are just the people giving us the directions because of the way it's set up. I mean, technically under Canadian law, the band council is not actually an arm of the federal government. The band council is elected by you. You actually have, your band council is actually actually what's called a custom band council. You've gone through a couple of processes to select a band council. But fundamentally, that's not the fight in this case. That's the one thing. The second thing is that the band council does not, you asked, does the band council have a treaty? And the band council does not have a treaty. It is the band, the Six Nations of the Grand River that have a treaty, regardless of who the day-to-day government is. And that's something that has been underlined, that just like it's Canada that has treaties with the United States. It's not the Liberal Party or the Conservative Party that has treaties with the United States. It's Canada that has treaties. In this case, it's the Six Nations of the Grand River have a treaty, we say, with the Crown, not the band council or not the hereditary council. It's actually you as a whole. And that's to the third point, is that we don't actually in our case say anything about the relationship between the band council and the traditional council. Like in fact, one of the things that was fought out when the HDI wanted to get involved in the case was whether or not this case was about that. And our position has always been that the question of internal governance is an internal governance matters. If it goes to court, there's different court processes for that. That this case is being brought on behalf of all of you It's not being brought on behalf of the council. It's not being brought on behalf of the HDI. It's being brought on behalf of the Six Nations of the Grand River. And if you look at the statement of claim, that's who it identifies at the top. It doesn't mention the Band Council.
When it gets to the damagement stage, I guess, damages stage, let me see here, or the negotiating stage for settlement stage, are we entitled to see a clear financial picture of both Canada and Ontario? Like, you can't just, I know you're going to use economists, but you can't just pull a number out of the air, right?
Yeah. So if we, I mean, we're sort of talking a lot about ifs, ands, or buts. Typically, the way these negotiations would work is that we have a lot of numbers. We have a lot of numbers in this case. Like, what's quite different about this case than, say, the Superior Robinson-Huron case is, like, there's a lot of quite detailed bank records. Like, we know how much money was being invested by Six Nations in Britain. We know what the interest rate was. We know what the mortgages were supposed to be. And so typically, well, we get into negotiations, like we'll be coming to the table with, well, not just economists, but accountants as well, who will say, look, the fact that the government, for example, didn't collect interest on the Selkirk mortgage on Block 5 means that the nation didn't get this much money. And this much money today is, with compound interest, is worth this much, right? And then the government will fight over, what the right interest rate should be and all those kinds of things. Likewise, like, we have a pretty good idea of how much money went into the Grand River Navigation Company, and we know that nothing came out, right? And so, again, like, there's some pretty standard ways for economists to calculate those numbers. Where it gets murkier will be, that it'll be a debate over, like, what are the chances of winning on this? What are, what were the right interest rates should be? All this kind of stuff. Like, there's all kinds of back and forth that can happen on those things. So, typically in negotiations with the government, like, it's pretty data-based. Now, in terms of knowing about the government of Canada, the government of Ontario, about their financial situations, I mean, the public finances are pretty transparent. So to the extent that they're saying, look, we are, we don't have enough money to pay this, like, we'll have a pretty good indication of whether that's true or false. But fundamentally, this case is about the money that this land was worth, right, which is a knowable thing, more or less, about the money that was gotten for this land and then misinvested in the Grand River Navigation Company, or money that no one can account for because it disappeared into the pockets of other people. And those are things that it's tricky, but it's not rocket science to come up with the numbers. So we'll be trying to work on a rational, transparent basis. And I will say that, of course, any settlement typically in a case this big will come back to the community for approval, right? Which is, that's going to be, and I suspect when the time comes, there'll have to be discussions with the hereditary chiefs. There will have to be some kind of vote in the community. There'll be discussion about that, what that process will look like. But we're a long way from that yet. Like, a negotiation like this is going to take 2 or 3 years if it starts tomorrow. So there's, and as of today, there is nobody negotiating with the government.
My last question is about negotiators. When it comes to that point, though, does your firm do the negotiating, or do you bring in, like, other negotiators that just do that?
So in some cases, the lawyers will do the negotiating. I will say, I think in this case, we'll be deep into the trial, And, like we focused on getting the trial ready to go. The chief and counsel have asked us to work with them to help to put together a negotiating team. We're trying to think about who's the right kind of negotiator to help lead these negotiations. We'll obviously have a role in supporting the negotiators, to help with, what are the strong parts of the case, what are the weak parts of the case, how should damages be approached, but the direction that we've been given is to help the chief and counsel put together a negotiating team that can drive these negotiations forward. And that's going to take a pretty high-powered senior negotiator. I frankly think, and maybe Max has a different feeling, but I frankly think that part of the trick to this case is going to essentially be having the litigation team focused on pushing the case to trial and saying to the government that if you don't honorably negotiate with Six Nations and reach an honorable agreement, that then we will have a judge sort this out. And so that's a huge job for us. Like, we don't want to be negotiating off the side of our desk. Does that help? Does that answer?
Yes, I just want to ask the question with regard to negotiations when we finally arrive at that point. If the government wants to offer as part of the negotiations land somewhere in Ontario, how will it be dealt with in terms of additions to the reserve, the ATR question? Because there's so many lands already that are supposed to be added to the reserve, and they're still not after years. Could that be negotiated within the whole scheme of things, that if they want to offer land back in some areas as part of the payment back, can we drop that ATR business and just have the land?
So there are settlements where there have been agreements to help speed up the ATR process. So the answer is that would be part of the discussion. Like you don't, like I've got to say, first of all, I would be, like my recommendation for what it'd be worth is like look for land close to home. You do not want land long way away. But it would certainly be a part of that you'd want to get land that could be added to reserve quickly. But again, like we need to have somebody to negotiate with first. Like right now we're sort of sitting at the table and there's nobody on the other side.
Hi, thank you. I have a question. It's about, I would hope as we go forward in these negotiations and in the land claims and various things that we're doing here, that we don't allow the government anymore to continue with this them and they. We have to, all of us that are here have to come together and be I and we and us. Everyone, keep your eyes open and listen closely to the things we're hearing tonight, to the things we're going to hear as we continue on, to make sure that we have at least a consensus and let it grow big among us, not you, not them, us. That way, when it comes time, we know that we are those generations that have suffered. We know NHIB, like the health has clawed into, cut back. We have people that are living like when so much hardship here. So don't overlook this living history that you look at today as we speak and come together. Everybody just stay tuned to make sure there's nothing in our hearts and our minds that would continue in the the they and them. Start saying us, because in the us, we can succeed in this. We put our heads and our hearts and our minds together. What he said was, what we are owed is much more than what the government can offer us. And I loved hearing that. But they still have a judicial responsibility back to Six Nations, to each of us. So I just want to share that. I have questions also, but I just want to put that out to all of us that are here tonight. Thanks.
Scano. I'm a muscle survivor. I've been locked up for 7.5 years, and they screwed me over then. And if we're asking for a monetary value for our land, let's see, what was I going to say? And if they're offering us some amount of money, and the government of Canada comes to the table honorably and says they will honor that amount of money, and if they don't, you got to go to trial, and we win, will the government of Canada appeal that? And how long will it take? Because I know the government of Canada probably will appeal it if we win, and it's going to go back to trial. How long will that take after the appeals? And will they appeal each case separately?
That's a really good question. So first of all, I'm sorry to hear that you've suffered through your life, and can understand how you might not feel very happy about the court system. But the question about appeals is a good one. And so the way the case works is that there's a first stage, and the government can appeal that first stage, and I suspect they will. I suspect they'll be the ones appealing. That doesn't stop the second stage from pushing ahead. Like in the Robinson Superior cases, their case was broken into 3 stages, and they kept pushing ahead with each of the other stages while the appeals went on. Appeals take a year or 2 from the time that the trial ends. And then if it goes to the next layer appeal, which is Supreme Court of Canada, that takes usually another 1.5 years or so. The exact times, who knows? So that has to be factored into things. That's just a reality of the system. I mean, there are a finite number of appeals, though. I mean, the reality is that on the first part of the trial, there could be at most 2 appeals. On the second phase of the trial, conceivably there could be 2 appeals, but the reality is on damages parts, it's harder for them to get past the first appeal. The way it works in Canada, to get past your first appeal, you actually need permission to go higher. You need to convince the judge that they need to convince the Supreme Court that there's a good reason for them to hear the appeal. It's not, they don't just have the right to appeal. So appeals are real, and
if we don't like their decision, and we appeal.
You have the right to go to the Court of Appeal, and then it's the same thing. Like if you want to go past the Court of Appeal, you need to ask permission to go to the next level. Show there's a good
timeline on that, like with all these appeals. How far could that run into the future?
Well, like I said, appeals, so in the Robinson cases are a good example. They added about 5 years on after the trial.
It's just like me from the mush hole. It kept going on, and then most of the people that were in there died before the money got to them.
Yeah.
There's only a few of us left, right? So that's what's going to happen to most of these people in here. By the time that timeline comes up, a lot of these people in this room is going to be dead.
Trust me, I'm very conscious of that.
Yeah. We got a limited time limit here on this because, you know, a lot of it's going to be dead and it's just going to
No.
will be gone.
And there's many ways this could work out. Like we are trying to convince the government, you know, and in the past, to settle parts of the case so that, you know, there can be, like there's some parts of the case that it seems to us that it's very hard to understand why the government is fighting them, to be honest with you, right? So it may be that part of the settlement will be, you know, parts of the case get settled and parts of the case get fought just for the kinds of reasons that you're talking about. And it's a sad reality that the court system moves slowly. And, you know, in 1995, when I started doing this work, it didn't seem that long. But in 2024, I'm very conscious of the fact that that court cases can outlive people. You know, and I wish I could say anything different, but I'd be lying to you if I didn't say that.
Hi, I was just wondering, if the Conservatives take power, will that ruin our chances at winning this case?
It's irrelevant to how this case goes. The courts don't care who the government is. And the reality is that this government is fighting just as hard as any Conservative government would. So the one thing about it, though, is that a Conservative government might be harder to get them to the negotiating table. But, you know, on the other hand, sometimes Conservative governments understand how to make a deal, you know, and so who knows? The reality is that politics is beyond our control, but it won't affect the court.
A couple of online questions. I think you touched on it a little bit, but people online wanted to know how long will this trial be and when would it start?
So all of these right now are estimates, okay? And it's beyond our control a bit. So the big thing is getting a trial judge. The best indication that we have right now is that we'll get a trial judge appointed sometime in the next 6 months or so, we're hoping. At that point in time, the sort of process of really getting ready for trial can start. And we're hoping that that process will get started towards the back end of 2025. And we're hoping, like in my dreams, we could start the trial at the end of 2025. I think more realistically, we'll be hearing first witnesses at the beginning of 2026, I think is more realistic. Now, how long the trial will take, that's one of the reasons we want a trial judge early, because, and I'll just give you did any of you watch the online evidence, like the last couple of weeks? I don't know if you remember the part at the beginning where the Crown was asked. So we had a couple of expert witnesses who are elderly, the Crown's witnesses. So their evidence is being taken in advance of trial. And so the Crown got to lead them first. And they filed hundreds of pages of expert reports. And we had to sit through days of the Crown just basically saying, you say this in this paragraph, say anything about it. Then they read another paragraph, and they go, say anything about that? Right? And it just took days and days of that, right? And a large part of the trial right now is set aside for witnesses basically being asked to go through the hundreds of pages of what they wrote before cross-examination starts. So we are going to be pushing some ideas with the judge to shorten the trial. Because right now, if we do it that way, people are saying that this trial will take over 300 days, right? That's 300 work days, right? So that's 3 years. We're hoping that we can convince the trial judge that there's better ways to do this and that we can make the trial shorter. So as it stands right now, though, if you're asking me to bet on this, is I would say we'll start hearing witnesses at the beginning of 2026, and it's going to take us 3 years to get through trial. And then a judge has to write their judgment, right, which takes time.
Hello. So you were saying earlier that the case is, the plaintiff in the case is Six Nations of the Grey River as a whole. It is not specifically the Band Council. I was wondering then how that would affect a potential settlement and how it's distributed. Would that money go to Band Council to be distributed among members? Would it go directly from Canada and Ontario to people who would be deemed eligible for any settlement? How does that work?
So again, we're talking about a settlement where we don't even have a negotiating partner yet. So typically in very large settlements where there's money passing hands, so first of all, when it goes to the nation as a whole, it is the Band Council is the government, and so they would, on the normal course of things, it goes into the accounts of the band's bank accounts and is managed in the way other band monies are. However, and the thing that I don't know, for example, a lot of bands, for example, have finance laws which would govern like how bands are managed. Like so, for example, up north, in the Robinson Huron area, some of the bands, for example, had laws that said, no more than 20% be distributed, for example, right? And so those are the kinds of things. Often in big cases where there's settlements with a large amount of money, you'll see the money being, how the money is managed being negotiated as part of the deal. Often what happens is that some will go into the general band fund, some will go into a trust, and some will be distributed. And that's often a part of the discussion with the band as a part of approving any deal, right? Because, in something like this, typically, there'll be an agreement worked out in draft. It will then be discussed with the community. Typically, there'd be a vote on it. And so, as a part of that discussion, the community would have input into what do we want to see distributed? What do we want to see go into a trust fund? What do we want to see used for band purposes? But again, this is kind of like counting roosters before the eggs have been even thought about. We're not counting chickens yet. So.
Well, we know with all lawsuits that the legal fees are the bulk of it. So I just wanted to know, are you getting a percentage of our settlement? Or, you've been working on this for 30 years.
So I've been working on it for 2.5 years.
Your firm has been working on it for 30 years, right?
Yeah. So not my firm, but listen, we're not doing a contingency fee. And I'll just speak for myself here. I don't do contingency fees, and I don't do contingency fees for a couple of reasons. One is because the fact that cases like this are so huge and require work being done well, you don't want your lawyers cheaping out. And the reality is that law firms, work on contingency fees often have, you've got to keep your firm working, so that's a problem. The second thing is that when a negotiation comes, is a contingency fee will often set up a barrier between the lawyer and the client, because, for example, what happens if the government says, we're willing to offer land? Well, how does that work in a contingency fee? Do you put a price tag on it and then take more money away from your money? The reality is that I want to be lined up with you. I want to be your lawyer, right? And so the reality is that that with a contingency fee, it sets up the possibility, particularly in cases like this, where it's not just about money, right? It's really about trying to arrive at a different kind of relationship with the government of Canada in many ways, and the government of Ontario. You don't want the lawyer to be thinking, oh, well, the only thing I want is money, right? So contingency fees are very risky in cases like these. The other thing about contingency fees, and this is happening in the Robinson-Huron case now, is that they often look good at the beginning and they look like a disaster at the end. Because so what's happened in that case is they had a contingency fee, I think it was 12.5% or something like that. And so 12.5% doesn't sound like a lot of money, but of course 12.5% of $10 billion is almost $500 million. And so the lawyers sent a bill, the lawyers have sent a bill for $500 million, and of course that's ended up in court. So the way that we do this is we charge our normal hourly rates, and we have to send in our bills every month. They get reviewed. We talk in advance about what we're going to do, so there's no big surprises about what's coming. And, given the size of this case, even at that rate, the fees will be a very small percentage of any overall judgment at the end, if it gets to that, right? Like this is, the amount of money involved in this case is immense. That's the way that we're working this, but, we don't. I have problems with contingency fees. You may gather from the way I'm saying it is that I'm very uncomfortable with contingency fees. Contingency fees work very well in cases like personal injury cases or big class actions where the only thing at stake is money, and often that like how long they're going to take and what the realistic parameters are. These cases are far too complex for this kind of thing.
I'm happy to add too, just for the other law firm that has been around a little bit longer, we're in the same situation. There's no contingency arrangement. We're here to be your advocate, and that's our bottom line.
Scano Sego, David Moses. There's something you said earlier when you first arrived. I'd like to, clarify and see if it has any bearing. I believe you said that over the years that you've been involved in cases in Indigenous and Aboriginal law, that Six Nations has come up in these cases and either been referenced or talked about it somehow?
So the reason it's come up is that a lot of the early cases involved Six Nations, and also a lot of the early policies. Like, for example, the Royal Proclamation had its origins, for example, in a lot of the things that happened in upstate New York with shady dealings with the Mohawks and such like that, that led to the kind of disputes that led to the government saying, look, no more of these little side deals on pieces of land and things like this. And so a lot of the policies that are underneath modern Aboriginal law come out of, say, for example, the Royal Proclamation, which has its roots in the relationship to the Crown and Six Nations. The other thing is that these cases involving in the 1830s, and 1850s, so these fights where people, for example, got brant leases, but then somebody else got a Crown grant for the same piece of land. And so people went to court saying, well, I have a Brant lease. Like, Joe Brant gave me this piece of land. The Six Nations gave me this piece of land. And then somebody else says, but I went to the Crown auction, and I got the piece of land in a Crown auction. And the court had to sort out who won, right? And so a lot of the principles that got picked up in cases like St. Catharines Milling, for example, came out of those cases. In fact, the St. Catharines Milling case, which is this famous case that's sort of at the root of a lot of Canadian case law, it actually mentions specifically one of the Six Nations cases about that. So I mean it quite literally that the Six Nations disputes over lands in the 1800s are at the root of a lot of Canadian case law. The other place where Six Nations comes up, and this is the earlier questions over here about the relationship with the hereditary chiefs and the elected councils. Obviously, a lot of the discussion around, respect for like how band councils work, what the status of band councils are, how hereditary leadership works, how the government of Canada has divided nations by playing off people within the community against each other, coming to the us versus we and them issue. The courts talk about what happened at Six Nations quite a bit. So, this piece of land and this community, has played a big role in the way in which Canadian law has thought about these things.
So my reason for asking that was, could this have any bearing in terms of this case moving forward, in terms of that Six Nations is one familiar or has been referenced and has been used as reference in other cases previously?
So I think the whole court system in Toronto, from the Chief Justice down to the Regional Senior Justice Case Management Conference, and the folks inside the government who are on the other side of this they take the view that this is an incredibly important case about how Ontario got set up, about how Canada got set up, and that and people are fully aware that there are huge issues of, I even think lawyers always call their opponents my friend. I think even our friends on the other side of this case, over a beer would concede that, there are bad things that happened here, and there's a fight about how and when and who should be responsible for those. I think there's a very deep sense in the system that this is a very important case that the courts have to take seriously and have to get right. I don't know. I should check in with Max to see if he thinks that I've gone off the deep end on that one.
Robert and I usually agree, and I can confirm I agree.
Thanks for that. So a follow-up question, and it has to do with question 5 here. When it says, when will we see the results? And they're pushing the Crown to enter into honorable negotiations and settle this case. This would be if the membership approves.
Right.
To be the quickest way to get a result. So I'm just wondering, what does that mean? Because it sounds like if you guys got an answer from them tomorrow to say, okay, we want to negotiate, that there hasn't been anything put in place to have the community already on board with this, so that it would perhaps delay things further.
So typically the way that negotiations in a case like this would work is that first of all, it never works as simply as somebody phones up and let's start tomorrow. The way it will really work is that somebody would phone up from the government and say, look, we're interested in seeing if we can establish a negotiation table, right? And so at that point in time, the first thing that would happen is there'd be a discussion about funding it, like typically these kind of negotiations are funding it. There'd also be a discussion at the nation level about, okay, what's our negotiation team and who's going to be on it? And then there would typically be a stage of initial exploratory discussions, right? Because to some extent, you can go into a negotiation, let's say you're buying a car, right? So if I walked into the Mercedes-Benz dealership and said, I'm interested in buying, that whatever fancy number it has, and he said, great. And I said, I've got $15, right? Well, that would be a quick end to that negotiation, right? And so typically you would see a quick end to that negotiation. There might be nothing to talk about. Then, if in fact it looks like there's more serious negotiations, typically what happens, and again, typically, I'm not saying it happens this way every time, is most communities that I've been involved in that have gone down this road of this larger negotiation, usually there's a period of negotiation where you see if we can get closer, and then there'll be community meetings, and there'll be a discussion with the community, like, we're having these discussions. We're sort of talking about these kinds of things, because often there'll be confidentiality agreements in place. And then, you'll get feedback from the community. Look, if we have a chance of getting some land, how important is this? What, for example, do you need to know that it'll get added to the reserve quickly? Would you be okay with it not being reserve land? For example, we've settled cases where it's not reserve land. If, for example, they come forward and say that they're willing to provide, an annuity of whatever per year. Like, would that be something, would that kind of thing work? You know, so you'd start to get feedback from the community about ideas. Eventually, when the agreement gets more solid, what you would typically do, and again, I'm talking typically here, right? Like, who knows what's going to actually happen, right? So I'm talking about experience from other negotiations. You'd then have a discussion with the government about saying, look, we would like to take what we have to the community, right? And you'd reach an agreement with the government about you can take this to the community because, you know, until there's an agreement, there's no agreement. So you're always a bit careful about what you just give out. You'd take it to the community and you'd see where things stand. At some point, you'll get to an agreement that will have to come back to the community. Typically, and again, typically, I'm not saying it's the same way every time, you know, there's a process of information sharing, there's information sessions, there'll be lots of meetings like this. Sometimes independent lawyers will be hired to give advice about is it a good deal or a bad deal. There'll be usually accountants involved to talk about is it a good deal or a bad deal. And then there'd be a vote, typically, right? Like, I can't imagine a big agreement like this not requiring a vote. You know, I would be, you know, and frankly, I doubt that the council would want it. I'm going to look at the chief here. She doesn't seem to be shaking her head terribly. I personally think that the council wouldn't want to do this without a vote, right? But it's these kind of negotiations are not like settling. You know, I used to do medical malpractice law before I did this stuff, defending doctors, right? You know, like there you'd go in. Sometimes you could settle a case in a day, right? A negotiation process for something like this will take months to years.
Thank you. Last question.
I think Lonnie might
Lonnie?
add something.
Before you get further, the table is set for anybody who's hungry and wants to eat. You can just go up and help yourself. You know, while this can carry on, sure.
Thank you.
I hate competing with dinner, but anyways.
So last question, I'm not sure who can answer this. Should Six Nations be successful, I'm just wondering about those negotiations in terms of discussing about how the community will utilize the success of this in terms of how it's going to be distributed, how it's going to be used, if there are individual payments, and how we will support the community or have the community be ready for something like that. And I'm not sure if council or you know, you guys
I think that's not like I can talk to the council about how to approach that. That's a big job, and I think it's one that becomes more real when there really is a negotiation, right? Like it's very hard to talk about that in the abstract. I think I've lost to supper.
If they lose in a sorry.
Scano. What happens if the negotiation or the court case is not successful? What does that look like? And the negotiations, if they're not successful, and any bad scenarios?
Yeah,
and I just want to also state before you go talk that the Haldeman tract and our land, it's not for sale and it never has been. So when you talk about compensation, it has to still remain ours.
Right.
Anyways.
Yeah, so look, as I said, anybody who goes into a court case saying that it's a 100% chance of winning, the reality is it is conceivable that at the end of it, for one reason or another, a court could say you lose. And in that case, then things are as they are now, is what it would boil down to. And, you know, there's no avoiding that. Question?
Yeah, so I just had a question about maybe for my own clarification. So if the outcome of this case were that Six Nations regains title over Haldimand tract lands, would it be still considered reserve lands, like still held in trust by the Crown, or would title actually be transferred to us as a community?
Yeah, so the thing is, the remedies section, the part of the case about like what the remedies are is at the back end. So any land, like if, let's say, for example, that a court said that, look, any of the remaining Crown land should be, on the unsurrendered part, should be recognized as reserve. Reserve means that it's the Crown has the legal title and they hold it for the nation. So if it ever comes to that, then it would still be, that would be the same formula, right? Unless you negotiated something, right? Like the reality is that, like in Western Canada, there's all kinds of nations that are negotiating to have their land transferred to them, which is what Joe Brandt wanted in the first place. And that is, that's a different relationship, but we're a long, long, long way from that kind of discussion.
Yeah.
Hello again. This might be another chicken before they, or count your chickens before they hatch question, but I did want to ask because I think it also relates to what you will be asking for rather than what you're expecting to get. There was the talk about possibly negotiating a revenue sharing part as part of the settlement, sorry. And I was wondering a little clarification about that. Would you be asking for revenue sharing from strictly federal and provincial revenue earned, or would it be like every, Walmart and Costco that's built along the Haldimand tract?
So definitely, that's roosters rather than eggs. But the way that I would think about it is this: is that if this land were still reserve land, okay? So in my head, the way I conceptualize this. If this land were still reserve land, you'd be the property tax authority, right? So the obvious target to my mind is I'd be saying to the government, you should be coming up with some kind of arrangement, because all property taxes collected is authorized under provincial legislation, to take a slice of the property tax and send it your way from all of that's collected along the tract. Now, the government will just swallow at that, because of course that money is what pays for roads and things like that. But I would conceptualize it as, you've got to come up with something that recognizes how much revenue the Crown is collecting every year from this land, and figuring out an appropriate approach to sharing it that would be respectful of the fact that this should have been reserve land, or potentially that there's still some underlying reserve interest. But a lot of this is that with negotiation, you've kind of got to be in it to see which way things go, because sometimes it's easier for the government just to say, we will send you a check of a certain amount every year, than to get into calculating revenue sharing, for example. So that's definitely a rooster's question rather than an eggs question.
Hi, thank you for coming. First of all, I wanted to say that I'm agreeing with you that we know that Canada knows that they're in the wrong, but we have also noticed that when they're in the wrong, they do everything possible to not give the proper information or data to the lawyers. We've seen that with the Mushrow, we've seen it with their survivors. They went way past the deadlines. What are you going to do to ensure that they're doing their due diligence to make sure that you're getting the data into the right hands for this potential negotiation?
So the reality is that actually a lot of the data is for the negotiation purposes, that is one reason why, to some extent, the starting, again, we don't have a negotiation happening yet. To some extent, there's a lot to be said for simplicity, right? Like, in other words, the simplest kind of negotiation is, please send us a large check, right? Because we have a sense of what the value is. You don't get into debates over how much tax did you collect this year, or did you artificially reduce the tax, or did you tax exempt somebody? You should, revenue sharing can be quite complicated, right? So in fact, the issue you raise points in favor of sort of trying to keep any final agreement as simple as possible. Revenue sharing, to some extent, becomes complicated for exactly the reason you identify. And you know, a large part of any kind of, you know, like in places where revenue sharing agreements have been negotiated, a big part of the agreement is negotiating data collection and data sharing, right? So, but again, you know, like using my joke from before, that's really a rooster's question rather than eggs question. We're a very long way from getting into that sort of thing. But it's a really good question.
My question is very simple. We have this big Grand River fault, right, coming from way up and going out to the lake. Do we lose access to that? Or do we gain access to the river?
To the river. So you should already have access to the river, right? So one of the claims that we have is for the bed of the river, and we're not sure where that will go. But technically, everybody is supposed to have the right to navigate on the river. Like everybody is supposed to have that right. Even I'm supposed to have that right. You know. So could you just tell me a little bit more about what you mean by access to the river? Because I might be missing something here.
Well, along the Grand River, they block it so that you can't even get onto the river. And then, like, say, the business that is on the river, we don't even get a discount if we wanted to go on a dinner cruise, as an example.
Right.
So this river is taken a long, long way, and we have no access because people that live on the river, you're chased away.
Right.
So that's important, in my mind, for our future generations.
So I don't have an easy answer to that question. I think I have to say is I don't have an easy answer to that question.
Hi, I was wondering, what is your process for identifying someone that's knowledgeable about the history of Six Nations, to gather evidence in your trial?
So are you talking about community members or yes? So actually, we've been working with Lonnie and Phil and Taylor and Dewey, you know, and reaching out to, you know, so we've been asking them, like, we've been asking for people who are knowledgeable about the history. Do you have any recommendations? Do you know people who are knowledgeable about the language? Do you have any recommendations? They've helped us set up interviews. I mean, one of the, you know, on the we and us, the we and they problem, one of the issues that we have is, you know, we would really like to hear from more of the people who, you know, perhaps are more affiliated with the Confederacy, because many of them are knowledge keepers. But, you know, we can't obviously make people talk to us. So then what we do is we've sat down with people and we've interviewed them. So we talk to them about, what's your knowledge? What's your experience? Tell us about this. And that's an ongoing process. And so far we've talked to a number of people who are quite promising, but we would like to talk to more, particularly people who know the language.
Oh, okay, there we go. What about like individual family cases, for example, like if someone was settled on a piece of land and then they were chased off of that land by squatters in Brantford, like what about, you know, like how are you handling that kind of information and stuff like that?
So if you know anybody who has that kind of story to tell, we would love to talk to them. Okay, like the reality is, of course, we're not in the community, you know, and so we're dependent to some degree on people reaching out, or so, like, for example, I know that there's Docksteaders still alive in the community. I'd love to speak to some of them, but if there's other people who you know, for example, because that sounds to me like you know somebody who has a family history of that. If they could get in touch with, yeah, if you get in touch with them, we would love to come out and speak to them. The more, like, I can't say we'd use all of it, but the more people we get that kind of story, because I'll tell you, one of the things we want to do is make the story seem real to the judge, right? And, you know, like, the reality is there's nothing like having people from the community tell the story to help make it seem real to the judge.
Hello. So I did want to ask a question about the expert litigation. I'm not sure if you can answer this. This might be a Crown thing, but maybe you could also give some insight into their decision making. So the expert litigations have been available to watch on YouTube and exclusively while they're happening. And I was just wondering, you know, why are they being live streamed on YouTube instead of recorded privately, you know, for future court use, and then taken away from public access entirely? Why are they only temporarily publicly available?
So the answer to that is, so they are being recorded for future court use. So they are being videoed, and transcripts are being taken. The reason they're being usually these things aren't live casts at all. This is something we pushed for to make it more accessible to the community, and the idea is to make it like it is in court, right? So the way it works in court is anybody is allowed to come and watch court while it's happening. Courts are open, but nobody's allowed to video them, and you're not allowed to. And when court proceedings are broadcast, it's just the law says you can't record them. So it's just those are the rules. After the case is over, or actually probably at some point in the case, the tapes will be filed as exhibits. At that point in time, those tapes will be available to look at then, but that's down the road.
We're going once. We're going twice. Anyone else have a question here? Can we have some parting words, maybe? Do we have any more questions in the audience? I think everyone. Oh, do you? Excellent.
Where can I? Oh, sorry. Where can I find where this is? I want to learn more about
Sorry,
it.
I can't quite hear you.
Where can I find where this is? I want to learn more about it.
Oh yes, there's a website. And almost all the documents that explain the case and the court decisions and everything like that, there's a website. It's in this, and there's an awful lot of information there.
Anyone else? Any other questions here? Oh, we got a couple.
No, in terms of the timeline, do you feel it would be advantageous for the community to become proactive and have some sort of plan of action to move this legal case forward?
It all depends on what the community did, but I will say this, is that to the extent that the community could encourage people who have knowledge, you know, language speakers that come forward, that would really help us get ready for the case and move things along. I think in terms of timing of things, is the reality is that I think the biggest thing that you can do is anytime you see a federal politician, ask them why haven't they appointed more judges? Like, that is the number one problem we face right now, is why are there vacancies in the judiciary? So that would be the most practical thing you could do for us, and is anytime you see a politician, why haven't you appointed judges?
I'm going to stand up. First of all, I want to thank Lonnie and Phil, and thank you, Robert, for being here tonight. But I want to thank Lonnie and Phil for all the work they've been doing on this for the last 30 years, or maybe more than that, because I know they're both getting pretty old. And we're very fortunate to have these guys in our community and continuing the work. So we've got to get some kind of a settlement before they're no longer here. So what I would suggest, I mean, we've been in court for 30 years, and it doesn't look pretty I'm hopeful that it's going to be resolved within like 5 years, 10 years. I mean, if there's going to be appeal after appeal. So I think what we need to do is come up with a plan for advocacy and for communication to try and get the government back to the negotiation table. I know there's been a number of things done over the years. There's been advocacy lobbies done on Parliament Hill. There's been presentations made at the United Nations. But I think we need to revamp that and come up with a good negotiation plan. You said you were starting to talk about getting a negotiation committee. And I think even though we're still in court, I think this should be done at the same time. So not only an advocacy plan, but a communications plan. You know, we just had Orange Shirt Day the other day, and the country was painted orange. So people are asking, what does reconciliation mean? Well, reconciliation means settling in Six Nations land claim or land court case. And so we need to come up with a good communications plan as well, and a plan to advocate on Parliament Hill and at Queen's Park. And how are we going to involve the community in that as well? So I think I'm glad that you're having these meetings, and glad to see so many people out in the community. But I would venture to say that a lot of people are thinking, well, how much money are we going to get and how are we going to divide it up? So we need to start thinking about that too. We need to start having regular community meetings and start getting feedback from the community. We are seeing what's happening in the Robinson Huron, where some people are saying we want to divide it up amongst every person and that's it. Well, we know we got 28,000 members on our band list. So, and some are saying we don't want any going to the band council, or we don't want any going to the community. Well, let's start having those discussions as a community. And I think a plan should be done for that as well. I mean, maybe by the time we finally figure it out as a community, because surely there's going to be disagreements, but maybe by the time we figure it out, we will have negotiated a settlement. Lastly, I think and I'd like more people to think about is, do we want to do it piece by piece? We've got 29 cases going, and do we want to do it by piece? You know, or do we want to say to the government, we know we're going to win, so why don't you give us some money in advance, and it can come off the final settlement? Those are the kind of discussions we need to have, and how we need to figure out how we can involve the community to do that. So that's just my suggestions, and I just want to thank, again, the Lands and Resources staff, James and Max, Robert, and for being here and for providing all the information. There's been some good questions from the community. Nyawa.
I agree with all of that. Can I just say one thing just to pick up on that? Is I'm sure you do know how fortunate you are, but it is true. The Lands and Resources Office is a huge asset. Like often I arrive at these cases and there's we know we have a claim. To have all the materials going that Phil and pulled together and that Lonnie prodded the government about back in the 80s, and I got to read all those old letters. You're so far ahead of the game compared to other nations in these battles.
Any other questions? Before we have just some parting words, possibly, if we could get our guests. Would you guys like a couple parting words? And then, of course, we'll have Lonnie and Phil say a couple of words as well. Thank you.
Just thank you for having us. It's great to see so many people engaged and interested in the case, and we're going to be speaking again.
No, and thank you very much. I've been down here a number of times now. It's really great coming down here, and it's great seeing so many people. It means a lot to me, at least, to actually see the community here. It's what makes it worth it to do this litigation and this kind of work. So I love your questions, and thanks very much for having us here tonight.
Now to everyone for coming out. I know it's being live streamed too, and we've got some questions from the audience on the live stream. So it isn't just this small. Small. It's a large group, but it's going out online. So this is just to from time to time we are intending to have these community updates. And it sounds like if we have to go to litigation route, it's going to take years and years to resolve it, so we're going to have continual updates to the community from time to time, and that's going to be our plan. We don't want to hide anything or leave anything in the dark for anybody. We want everybody to know what's going on because everybody has an interest in this court case. So we'll always be open to the community, to the population, to the membership as much as we can. Bill, do you want to say anything?
I guess one of the things is, and it has been pointed out, that the Lands and Resources Office, when we started working with them, they were just a bunch of young chicks. Now they're very wise ladies, so they deserve and hanging in there. And it has not been easy, When we dared to start this litigation in '95, Canada tried to teach us a lesson. They cut off all of our funding. And a lot of people don't know this. Not one of those people in that office left. They stuck it out. And that's what has brought us to where we are today. So they're the ones who are the real backbone and memory sticks to all of this. So we couldn't do it without them, to be quite honest with you. So if you see them around, give them a pat on that, I was going to say ass, but head, I guess. But anyways, and thank you for coming out. We've got a plan. You're absolutely right. The comments from former Chief Ava Hill said we got a plan for success, because if we don't, I think we're going to be self-destructive. And that's the only thing I fear about this. I don't have no fear that we're going to be on the short end of the stick in this litigation. I think we may not win her all, but we're going to get our fair shake, I'm sure. So now we'll go. Thank you.
Thank you very much, everyone, for coming. Gentlemen, thank you very much. We're going to have our good friend Joe Martin come up. He's going to do our closing for us. And again, thank you very much for all of the questions. It was a great night, and enjoy the food.